Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 38 of the Case a Day series journey covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Today, I'd like to now move away from the mens rea test of indirect intent and move towards covering recklessness as another possible mens rea test. First, we should know that many criminal offences can be committed with either intention, which can be either direct or indirect, or recklessness. Recklessness, and more specifically, subjective recklessness for the purposes of this recording, is a lower level of mens rea than both direct and indirect intention. Subjective recklessness refers to where the defendant knows or is aware that there is a risk of a consequence or outcome or result happening and goes on to take the risk anyway. What I've just explained comes from the case of R.V. Cunningham, 1957. Recklessness is a form of mens rea which involves the defendant taking an unjustifiable risk. However, similar to intention, the recklessness test we use in criminal law for mens rea today is subjective too, i.e. we focus on what is going on in the defendant's mind rather than compare them to a reasonable person standard. So, to be subjectively reckless, the defendant must recognise or appreciate the risk that they are taking and go on to take the risk. The test for subjective recklessness was created in the case of R.V. Cunningham, 1957. At trial, the defendant was charged with maliciously administering a noxious thing so as to endanger life under Section 23 of the Offences Against the Person Act 1861. Be aware that the court held that the term maliciously referred to the mens rea required for this crime, i.e. intention or recklessness. In this case, the defendant wished to steal money from a gas meter located in an empty house, so he ripped it from a wall. This led to gas escaping and seeping through the small cracks of the wall of the neighbouring property, which led to his future mother-in-law being poisoned as she slept. However, the defendant, Cunningham, was found not guilty at trial as it was decided that he was not reckless. This is because it was held that although he may have been able to appreciate or realise the risk of gas escaping and poisoning people in the house he ripped the gas meter off the wall in, he wouldn't have been able to appreciate the risk of gas escaping into the house next door, poisoning people. As a result, Cunningham was deemed to not have an intention and to not be subjectively reckless, and therefore was not guilty. This case did happen to create the subjective test for recklessness, and so is a very important case. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you Wednesday.